Good morning and welcome to our webinar, Greenwashing, a practical guide to obligations and litigation. Thank you for joining us. Today we will explore the critical issue of greenwashing, focusing on legal obligations and potential consequences for companies. I'm Victoria Barnes. I'm a senior associate in the environment team at Burges Salmon. I advise across the full spectrum of environmental law and regulation, but with a focus on contentious environmental work. Issues involving climate-related liability and greenwashing are increasingly on my clients' agendas and radar, so I'm very pleased to speak about the topic of greenwashing with you all this morning. I'm delighted to be co-hosting this webinar with 39 Essex Chambers and to be joined by Catherine Dobson and Ruth Keating. Catherine is a highly regarded barrister, known for her expertise in public law, regulatory and environmental law. Catherine was called to the bar in 2009, and she's been involved in a number of landmark cases, such as the challenge to the former government's decision to support a third runway at Heathrow Airport, and in the Miller litigation, which involved the challenge to the prorogation of Parliament. Catherine will be looking at greenwashing through the lens of public law litigation. Ruth Keating is a junior barrister specialising in energy and construction disputes, environmental and public law. Called to the bar in 2017, she's acted as a junior counsel in significant cases, including most recently in Finch and Surrey County Council, and the forthcoming appeal in the Supreme Court of C.G. Fry. Ruth will be exploring the private law implications of greenwashing. To get us underway, though, I will try to set the scene with an overview of the key regulatory frameworks governing greenwashing and bringing some colour to that with a few case study examples. If you do have any questions or would like to share any comments, please add those to the Q&A and we'll do our best to pick those up at the end of the presentation if time allows. So, turning to my first slide, please. I want to briefly touch on what is greenwashing and what we mean by that term. I'm sure those of you joining us today are very familiar with this term, but I think it's important to note that there's presently no universal definition, although we're certainly getting closer to that with the evolution and convergence of regulatory and legislative developments in this area. Generally, what we mean by greenwashing is unsubstantiated or misleading claims, whether made intentionally or not, about a business's environmental products, services, operations, or performance. Greenwashing can also describe environmental claims that omit or hide information. And this can include misleading statements made in marketing materials or on products, in companies' annual reports and filings, and other communications in public statements or advertisements. A common form of potential greenwashing is the use of broad or vague terminology, such as eco-friendly or sustainable. Importantly, though, it's not just what you say, but how you say it. So the use of green packaging or labeling, symbols, logos, graphics, imagery of nature or wildlife can also imply environmental friendliness. Next slide, please. So briefly touching on the scale of the problem and why that matters. In the last 5 years, accusations of greenwashing have surged, and I've included a few stats on the slide that illustrate this. And greenwashing really matters because it can disrupt consumer and investor behaviour, it can erode trust and lead to reputational and financial consequences for business. And the stakes are high, as we all know. We have a limited window of opportunity to address the urgent climate and biodiversity crises. So sorting the sustainability fact from the fiction is more important now than ever. Next slide, please. So let's turn to some case studies before we delve into the regulatory frameworks. And I want to do this because I want to kind of illustrate what regulators consider as greenwashing and why and where their focus has been. So the first of the decisions I want to look at is by the Advertising Standards Authority, the ASA, which is the UK's independent advertising regulator and has been the sort of trailblazer on greenwashing. The first one I've chosen is Lufthansa, which is one of a line of decisions against airlines, including Air France, KLM, Etihad. And I've picked this example as it illustrates vividly the dangers of absolute claims, the need for evidence to back claims up, and the importance of the context within which claims are made. So in Lufthansa's ad, which is on the slide, or its taglines on the slide, connecting the world, protecting its future, and similar language along those lines was used by other airlines. In each case, the ASA considered the ads to have misled consumers about the sustainability of air travel in breach of the ASA's advertising code. And I've noted some of the rule breaches on the slide. Now, why was that? Well, in all the cases, the ASA found the claims didn't include any detailed substantiation or information on the basis of the claims. In Lufthansa's case, whilst the ASA acknowledged Lufthansa's view that the claim connecting the world, protecting its future in isolation was ambiguous and not clearly linked to the environment, the ASA considered that the claim was likely to be interpreted by consumers as a reference to how Lufthansa's approach to aviation was protecting the future of the world. Whilst Lufthansa said its campaign was based on specific steps being taken by it to be more environmentally friendly, such as its aspiration to be carbon neutral by 2050, its claim protecting its future was not qualified with that information. Although Lufthansa also had initiatives and targets that the company was committed to delivering to in pursuit of its stated goal, many of those initiatives were targeted at delivering results sort of years into the future or decades into the future. And the ASA considered that there was no environmental initiatives or commercially viable technologies in the aviation industry which would substantiate the absolute green claim protecting its future. The ASA therefore found the basis of the claim had not been made clear and had not been adequately substantiated. So turning to the next case study that I've chosen, this is the ASA's decision against Repsol and its claim about biofuels and renewable energy sources. And the key issue in both of the decisions against Repsol was the omission of significant information about the overall environmental impact of Repsol's business activities. Again, there have been a line of important decisions by the ASA against oil and gas giants, all of which made broad claims about the green transition plans those companies had, and all tripped up because these claims and the reality of their high carbon business models was out of kilter with the overall impression given in their ads. For Repsol, the ASA specified that including further information to contextualize Repsol's path to net zero and the role of biofuels within that plan was material to creating a clear and accurate message to consumers, and Repsol had not done that. Significantly, and I think it's important for others out there when looking at their advertisements, is that it wasn't enough that Repsol had included links to other information to its website in the ad itself. The accuracy of the representation was therefore assessed by the ASA on the basis of the content of the ad itself, primarily the text and the images, and that links to additional information, although useful, were not sufficient to balance and otherwise what the ASA considered misleading or incomplete depiction. Interestingly, with this particular case, the ASA's equivalent in Spain, Autocontrol, took a different approach. So Autocontrol actually narrowed the question down to the factual content of the advertisement alone and didn't frame the ad within the broader activities of the company. And this really demonstrates the challenges multinationals face when operating in different jurisdictions, when regulators can take different approaches. Next slide, please. So I've added a couple of other case studies to the slide that people can sort of reflect on. There's not time to go through these, but they are Intrepid, and the next slide is Oatly. And I've included them because they're very interesting, Intrepid in particular, on the ASA's approach to considering the full life cycle of products and services, and Oatly is very useful on comparative claims. So do look at those in your own time. I want to turn now to the Competition and Markets Authority. So if you could just move and to the next slide, please. So this is the one want to look here at the CMA, which is the UK's principal consumer protection authority, and its greenwashing investigations. I think it's fair to say that the CMA has been sharpening its focus on greenwashing and being a little bit lagging behind the ASA early on. And it's undertaken a number of investigations since issuing its Green Claims Code in 2021. And its focus has been on the false and misleading environmental claims that affect consumers. And it's had a number of priority areas. They're listed on the slide, but that's the fast-moving consumer goods sector and the green heating sectors. On the fast-moving consumer goods side, I'll briefly touch on the CMA's investigation against 3 fashion retailers, which was launched in 2022 in relation to their sustainable ranges. Several issues were examined by the CMA, including whether the businesses were using broad and vague terms, which created the impression that clothing collections were more environmentally sustainable than they actually were, the potential misuse of statements about accreditation schemes, and whether actually enough information was being provided to customers about the products included in the company's eco ranges. In March last year, the CMA announced that it had agreed formal commitments, or what we know as undertakings, with the fashion retailers to change the way they display, describe, and promote their green credentials when marketing their products to consumers. And that actually brought the investigation to a close. Interesting, and this is the point I want to make on this, is that at the same time as publishing the undertakings, the CMA released an open letter to the wider fashion industry about misleading environmental claims. And this was then followed a few months later by the publication of a practical compliance guide to the fashion industry, as well as the issuance of letters of concern to 17 well-known fashion brands, advising them to review their sustainability claims. Whilst the undertakings open letters guidance are on their face sector specific, the principles are applicable across sectors and will inevitably be applied more broadly. So I do encourage businesses, companies to look at these and reflect on them, because they do kind of reflect the CMA's current position on environmental claims and provide a very useful steer on things like language, accreditations, the use of environmental targets, and also the processes that should be in place to make sure claims are accurate and not misleading, including supply chain obligations. And what's been happening at the CMA on the fast-moving consumer goods side, I think is very much indicative of how the CMA intends to approach tackling the issue of greenwashing, namely investigating these paradigm cases and companies to spotlight issues, thereby providing industry benchmarks for how products and services should be marketed, which is then followed up with sector guidance to help businesses stay on the right side of the law, so to speak. So let's turn to the legal frameworks. If I could have the next slide. And firstly to consumer and business protection law. I think the first point to really bear in mind is that in the UK, environmental claims made about products and services are regulated by a combination of legislation, guidance, and industry self-regulation. So in terms of consumer law, we have the newly enacted Digital Markets Competition and Consumers Act 2024, which was enacted in the nick of time before the general election last year. And on the consumer protection side, the Act largely copies across the Consumer Protection from Unfair Trading Regulations 2008, although there's some amendments, and one which I will touch on in a minute. And significantly, the new Act has given the CMA for the first time direct enforcement powers for breaches of consumer protection law, which has really given the CMA some teeth in this area. There's also the Business Protection from Misleading Marketing Regulations 2008, which regulates business-to-business marketing, and the CMA has power to directly enforce those regulations under the new Digital Markets Act. So just coming back to the changes under the Act. Now, the Act makes it unlawful for business to engage in unfair commercial practices, which was the case under the consumer regulations. And this can include making misleading statements about a product, omitting, hiding material information. And this is how greenwashing practices are captured or being captured by consumer protection law, greenwashing itself not prescribed explicitly. Now, many business will be familiar with the concepts of misleading actions or misleading omissions, but perhaps less familiar is the professional diligence requirement. Now, this broadly considers whether the commercial practice falls short of the standard of skill and care which a trader may reasonably be expected to exercise towards consumers. It goes further than the content of consumer-facing statements, such as advertising, for example, and allows the CMA to actually examine behind the scenes of commercial practices that have an adverse impact on consumer behaviour. And the new Act has actually altered the formulation of the unfair commercial practice test and therefore the diligence requirement, which may make it easier for the CMA to enforce on that basis. And the professional diligence requirement has actually been central to a number of CMA enforcement cases. For example, we understand it formed part of the basis of the CMA's requirement to fashion retailers to implement supplier due diligence measures in their undertakings, which I discussed on the previous slide. The new Act also has the power to amend the list of unfair practices, so we could see the range of prohibited actions expanded, as we've seen in Europe with the Empowering Consumers Directive. Significantly, as I mentioned as well, the Act brings in the enhanced enforcement powers for the CMA. So the CMA will now have its ability to directly enforce against non-compliant businesses for breaches of consumer protection legislation and actually impose very significant fines of up to 10% of a business's global annual turnover. If I go to the next slide. Now, on the guidance side, so we've got the law and now the guidance. To assist businesses to comply, the CMA has issued detailed guidance on environmental claims. I've already mentioned the Green Claims Code in my presentation so far. So the code, which was published in 2021, is based on consumer and business protection law, and it sets out 6 principles, which I've detailed there on the slide, that businesses should follow and apply when making environmental claims. And the code breaks down the principles in detail, so do take a look at the full code. But really a kind of key theme running through it is that businesses should proactively put themselves in the position of the consumer to try to understand how specific language and presentation may be interpreted. Next slide, please. As for the ASA, this is the authority which oversees the set of self-regulatory rules, and there's 2 sets. These are found under the BCAP code, the broadcast code, and the CAP code, which is the non-broadcast code. I've identified the CAP code on the slide there, which applies to, among other things, advertisements in newspapers, magazines, other electronic or printed material, as well as communications on websites. The key section of the CAP code is section 11 for environmental claims, and I've noted some of the key rules on the slide. In addition to those specific rules, the ASA has also issued guidance on the interpretation of the CAP code in relation to environmental claims as well as social responsibility. And it's well worth a read through, as it includes some examples on approaches that are likely to be problematic. And one interesting recent development to note is actually how the ASA is actually looking at green claims on the basis of whether they breach rules around environmental claims, but also on social responsibility rules. And the decision against Toyota's Born to Roam is an example of this, and it'll be interesting to see whether that trend continues. The next slide, please. Finally, very briefly on the FCA, as I'm running out of time. The FCA's long-awaited anti-greenwashing rule came into force in May last year, and this rule is part of the wider sustainability disclosure requirements regime. The anti-greenwashing rule has a broad application extending to all FCA authorised firms that either communicate with clients in the UK in relation to products or services, or which communicate or approve financial promotions to persons in the UK. Now, the effect of the rule is that any reference to the sustainability characteristics of a product or service must be consistent with those characteristics and also must be fair, clear, and not misleading. Now, whilst this is to a large extent replicates existing rules for financial promotions as contained in the FCA's existing handbook, by imposing these specific standards applicable to greenwashing, the FCA is not only bringing ESG compliance into sharper focus than ever before, but also aligning itself very much more closely with other regulators, both domestically and abroad. So I'm going to pause there and I'll be back to do some wrap up at the end, but I'll now hand over to Catherine. Thank you.
Thank you, Victoria. So I think what we can see from Victoria's presentation is that greenwashing is becoming the subject of increased regulatory activity. And enforcing these standards will, of course, be a matter for regulators, but as regulatory activity increases, there's also the prospects of legal challenges to the decisions of regulators as well as inaction by regulators. It's relatively rare for regulators to face judicial review claims particularly from third parties, but it is possible. And as greenwashing becomes an area of focus for regulators, I think we may also see the regulatory approach to greenwashing issues attracting scrutiny through public law challenges. And this is illustrated, we go on to the next slide, by the recent challenge brought by Client Earth against the Financial Conduct Authority, challenging its decision to approve and publish a shares prospectus of the oil and gas company Ithaca Energy. So the background to this claim is that the FCA is required under the Financial Services and Market Act to approve and publish a prospectus before a company can issue shares. And the prospectus must comply with the prospectus regulation, the European prospectus regulation, which includes a requirement that a prospectus addresses risk factors affecting the issuer to enable investors to make an informed decision in their investments. Client Earth argued that Ithaca had failed adequately to describe the climate-related risks faced by the company, and that this was a breach of Article 16 of the regulation. So Ithaca's prospectus acknowledged that that climate change presented risks to the oil and gas industry at a sort of generic level, but what it didn't explain was how significant those risks were for it as a company, given its stake in the Cambo and Rosebank oil fields. And this is what Client Earth said, that they should have explained in more detail the specific risks facing Ithaca. So Client Earth challenged the FCA's decision on 3 grounds. The first 2 grounds related to the argument that the FCA had erred in law in the way that it interpreted and applied the prospectus regulations. And then the third ground of challenge was a rationality challenge. Client Earth argued that the FCA's conclusion that the prospectus contained sufficient information material to an investor to enable that investor to make an informed decision was irrational. Now, permission to proceed with the judicial review claim was refused both on the papers and at a renewal hearing before Mrs. Justice Lang. But there are 3, so it was unsuccessful, didn't get to the substantive hearing. But I think we can draw there are some interesting points to draw from this, what I think is the first challenge to a regulator's decision in the context of a greenwashing decision. The first is that Client Earth was found to have standing to bring the challenge. I'll return to that topic in a moment. The second point is that the court rejected an argument that the claim was an Aarhus Convention claim, so as to attract cost protection. And the third is that the court emphasised the high threshold for challenging decisions of a regulator such as the FCA. So I'm going to return to each of these points in more detail in a moment. But in brief, the Client Earth challenge, as I say, I think it's the first public law challenge to a regulatory decision in respect of the adequacy of the regulator's approach to what might be said, what allegations of essentially greenwashing, or what a company says or omits to say about its environmental credentials and the environmental risks that it faces. But I think this may be the sign of things to come, as I say, with the increased regulatory activity in this area. So in the remaining time available to me, I'm going to consider the types of public law challenges which might be brought in this space. So who might bring these challenges, who might be the target of these challenges, what grounds of challenge might be advanced, and the prospects of them succeeding, and also some of the procedural issues that might arise. So if we go on to the next slide, and go on to the following slide, looking first at who might bring these challenges, the obvious contenders are NGOs, civil society organisations. If we look in other jurisdictions and indeed domestically, these are the types of claimants that are the driving force behind novel strategic litigation in the environmental sphere. But there may also be challenges brought by other bodies. Of course, an entity that's subject to regulatory action, for example, a company whose advertisement has been declared to be misleading by the ASA, who's been the subject of an adverse investigatory finding by the CMA, might challenge that decision. There are internal procedures for challenging those decisions, but if those are unsuccessful, then the entities might have recourse to a judicial review challenge. It's also possible, and if we look at the types of judicial review claims that have been brought against regulators such as the FCA and the ASA in other contexts, that public law claims can be brought by other private entities, for example, competitors. And I put on the slide there a few examples in other contexts of such claims. So the first is the UCOS oil case. That was a case discussed in the Client Earth decision, and indeed may well have been a model for Client Earth bringing that regulatory challenge. So UCOS brought a claim for judicial review of the Financial Services Authorities, that's the FCA's predecessor, the FSA's decision to approve a prospectus relating to the public offering of shares in Rosneft, a company owned by the Russian government. And the challenge was brought on the basis that the prospectus, it was irrational for the FSA to approve the prospectus when the prospectus had failed to set out the strength of a claim that was being brought by UCOS in the European Court of Human Rights regarding the expropriation of UCOS's assets by Russia. UCOS also argued that the FSA had made an error of law in the way that it applied the active state doctrine in its decision. So what you can see there is a very similar type of challenge to the challenge that was brought by Client Earth. The court refused permission to proceed with the judicial review claim in that case, but it is a good example of a private entity challenging the decision of a regulator in respect of a competitor. The next example, Sainsbury's supermarkets challenging the decision of the independent reviewer of Advertising Standards Authority adjudications. So as Victoria explained, the ASA is responsible for investigating and adjudicating complaints of breaches of the CAP code. And here Sainsbury's challenged the decision of the ASA's independent review, so that's the internal appeal mechanism essentially, its decision to refuse a complaint that had been made by Sainsbury's against Tesco's price promise, price matching scheme. So Sainsbury's had argued that by matching some products which were ethically or environmentally accredited, such as, if we can go on to the next slide actually, here, yeah, if we, so accreditations such as the Fair Trade Standard, MSC accreditations, Sainsbury's argued that matching those products with products that are not environmentally accredited, Tesco was breaching both EU law and the CAP code. Sainsbury's claim was unsuccessful on the facts, but again, it's illustrative of the type of indirect horizontal challenge that might be brought against a regulator, such as the ASA, by one company targeting the inadequacy of regulatory action in response to greenwashing claims. And then finally, if we go on to the next slide, a third example of this sort of horizontal challenge, the ASA here issued a decision that it was not misleading for part fibre broadband services to advertise their broadband services as fibre. And that was challenged by City Fibre, a company that offered full fibre broadband, and it was essentially arguing that companies who only offered part fibre and they would say inferior fibre services were gaining an unfair advantage. Again, the claim was dismissed, and you see a theme here that these challenges are not, on the whole, successful. And the court, in dismissing the claim, emphasised that whether or not an advertisement was misleading or not was a matter for the expert judgment of the ASA. So it's a very high threshold for a successful challenge, but it is, again, another example of one competitor challenging a regulator's decision in respect of another competitor company. In terms of the target of these challenges, if we go to the next slide, obviously this will include regulators whose remit involve policing greenwashing issues. So Victoria's gone through the key regulators in this space, the CMA, the ASA, and also the FCA. But what about other public bodies with oversight of activities in the public realm, which may involve greenwashing claims? And one example that came to mind, thinking about the role of the ASA and the CAP code, a number of public bodies, including Transport for London, have advertising codes which govern the advertisements that they authorise to run on their services. So TfL has a code that says what advertisements they can carry on its buses, tube, other property that it owns. And TfL regulates that on the basis that advertisements should not conflict with the CAP code. So if TfL were to authorise an advertisement that carried a misleading greenwashing claim, for example, on the side of a London bus, could it be challenged for taking a decision that's in breach of its own advertising code? Such a challenge was brought, not in the greenwashing context, but in a different context, when a charity sought to challenge a decision by TfL to refuse to allow an advertisement for gay conversion therapy to be carried on its buses on the grounds that it was likely to cause widespread or serious offence and related to matters of public controversy, which it said was contrary to its code. So Core Issues Trust, the charity seeking to place that advertisement, challenged the claim on the basis that it breached the charity's Article 10 rights. The claim was unsuccessful, although it did go up to the Court of Appeal and back to the High Court before that conclusion was reached. But what it illustrates is the potential for greenwashing issues to arise in other realms of public law decision making and beyond those of the core regulators currently focusing on greenwashing claims. Now to the next slide, in terms of grounds of challenge, a common theme of the decisions that I've discussed so far, the Client Earth Challenge, the Sainsbury's Challenge, the UCOS Challenge, is that the courts have emphasised that decisions of regulators are only challengeable on conventional public law grounds. And in each of those cases, the same grounds of challenge were advanced. So the arguments were made that the regulator had failed to correctly apply the relevant legal test. So in the Client Earth Challenge, it concerned the interpretation of Article 16 of the prospectus regulations. In the Sainsbury's claim concerned the correct application of the CAP code and the EU directive in play. And the second ground of challenge advanced in these claims was that the regulator's conclusion was irrational. So those are the main grounds of challenge that have been pursued in the cases that have been brought so far, but also possible to see that in this area, decisions could be challenged on other conventional public law grounds. So the obvious ones being that the regulator failed to take into account material considerations when reaching its conclusion, or that the regulator failed to carry out sufficient inquiries into the issue, the so-called Thameside ground of challenge, before reaching its conclusion. And particularly for challenges brought by the entity that is the subject of regulatory action, there may be procedural fairness challenges. But, and this is key, I think, in terms of looking at the prospects of these sorts of challenge succeeding, in all of the cases that have been considered, that I've considered today, the courts have found that the law that the regulators are applying in this area don't impose hard-edged requirements. Their application is generally a soft-edged question involving a matter of judgment for the regulator, and the courts have emphasised that the court will be slow to interfere with that evaluative judgment. So we can go on to the next slide. See there a couple of examples of how the courts have articulated the threshold. So in the Client Earth permission decision, Mrs. Justice Lang emphasised that the decision were matters of judgment for the experienced body, the ASA. They're matters of fact and degree, and the ASA's decision had come nowhere near being Wednesbury unreasonable or irrational, so very high threshold set. Likewise in the Sainsbury's supermarkets challenge. Then finally, in terms of the procedural issues that might arise in these cases, the first is the issue of standing that might arise. So, of course, a person that brings a claim for judicial review must have standing to bring the claim. They must have a sufficient interest in the matter to which the application relates. And as I mentioned earlier, in the Client Earth challenge, Client Earth's standing to bring the challenge was contested. In most cases, most judicial review cases, standing isn't an issue, but it was challenged there. Argument was heard on the issue, and Mrs. Justice Lang concluded that Client Earth did have standing to bring the claim because of its long-standing interest in environmental issues. It's a body with expertise in this area, and that its mission is to ensure that public bodies act in accordance with their legal obligations in relation to the climate crisis. So Mrs. Justice Lang found that Client Earth did have standing, and this is entirely consistent with the liberal approach which courts have tended to adopt to the question of standing in public law challenges. However, there is a recent run of cases, and a number of which involve challenges brought by the Good Law Project, in which the courts have applied greater scrutiny to the question of whether or not bodies bringing challenges, particularly where they're brought not by individuals or not on behalf of groups of individuals directly affected by a claim, but in the public interest, to determine whether that claimant really does have sufficient interest in the matter. So some of the themes that come from those cases are that the courts will not accept that just because a decision may be said to raise an issue that's in the public interest that should be litigated, that doesn't mean that the claimant proposing to bring the challenge will necessarily have standing. It won't be enough necessarily for the claimant to show that they have a genuine interest in the issue to satisfy the sufficient interest test. And the courts are concerned to avoid claims being brought for ulterior motives, so by busybodies or by claimants seeking to achieve ulterior objectives through bringing a judicial review claim. Overall, the courts will continue to look at the case in the round, and you can see that in the approach of Mrs. Justice Lang in the Client Earth case. But in challenges to decisions of regulators involving companies that might be brought by, for example, competitor companies, I think the courts will be more astute to interrogate the motives behind these challenges. The second, and if we can go on to the final slide, the second issue that may arise in this space, so if we go on to the next slide, is the issue of costs. So one of the most significant barriers to bringing judicial review proceedings of a regulator's decision is the costs involved in such challenges. So in the Client Earth challenge, Client Earth sought to rely on the cost capping regime available for Aarhus Convention claims. And Mrs. Justice Lang rejected the argument that the claim was an Aarhus Convention claim. So in order to come within the Aarhus cost capping regime, it's necessary to show that the claim concerns a contravention of national law relating to the environment within the meaning of Article 9.3 of the Aarhus Convention. And Mrs. Justice Lang held that neither Section 87 of the SFMA nor the prospectus regulations concerned what form part of the UK's environmental law. She said the purpose of these regulations and provisions was to protect investors and that the any connection with the environment was incidental and remote. So question will arise, I think, as to whether the same argument could be made in respect of the statutory provisions, guidance, codes that Victoria discussed earlier. I mean, it seems to me that the argument that codes and guidance which have been developed expressly to address greenwashing issues and relate directly to environmental claims made by companies is not a matter relating to the environment, but this is an issue that may well come to be determined if and when another claim is brought against a decision of a regulator in this field. So I think with that, I'll hand over to Ruth to talk about private law claims.
That's great. Thanks, Catherine. So I'm going to be going through the private law implications of greenwashing. And I think when we're thinking about private law claims, it's helpful to look at both the potential causes of action, but also asking that question of who would be the claimant in the way that Catherine did. So first, I'm going to take a look at where we are with climate and environmental litigation generally against companies and corporates. And then second, I'm going to look at 3 developing areas of case law to see how this litigation might develop. So first on your screens, you'll see some research from the Grantham Research Institute on Climate Change and the Environment. Of course, a very well-known organisation to many of those tuning in. And I think it's helpful to look at those headline points that have come out in the latest report. So first, the headline point is that climate litigation against companies is on the rise. The second point is interesting, which is when you take a deep dive into that data, what do you see in terms of the numbers? And we can see that there are 230 climate-aligned lawsuits, as they're defined, against corporates and trade organisations since 2015. But what's really interesting when you look at that number is that 2/3 of those cases were filed since 2020. So quite a stark upsurge in terms of those cases. And then the final point and relevant for our discussion today is that when you look at greenwashing claims or climate washing claims specifically, there have been more than 140 cases filed, so a very rapidly growing area of litigation. But specifically, when you look at the success rate, it tends to be just above 70%. So different to the success rate that Catherine was talking about in those challenges to regulators. There is a bit more success seen in those types of cases. In terms of the drivers of litigation, well, there's a whole spectrum of cases that can be brought, and it's clear from the examples that Victoria and Catherine have been through that the potential range of claims is broad. So, of course, we clearly have examples of regulators taking enforcement action. That's the area many of us will be most familiar with. But what's really interesting when you look at the cases in this jurisdiction, but other jurisdictions as well, is that that regulatory action can be a catalyst for private law claims. So competitors seeking to protect their market position by trying to restrain greenwashing conduct. You have shareholders suing in relation to corporate disclosures. And of course, finally, you have strategic litigation backed by activist groups and consumers. So I'm going to focus on those 3 categories of claimants in terms of private law greenwashing claims. So competitors, consumers, and then shareholders. So the first case to go through, it's a competitor case. We'll recognise the name on the screen because, of course, it's an interesting example of the Repsol decisions continuing, which Victoria spoke about. And this is really the next stage in that legal story. So it's the case of Iberdrola and Repsol. The case was initiated in February 2024 in Spain in the Commercial Court in Santander. And the claimant and defendant, so Iberdrola is a major renewable energy company. And of course, we're aware of who Repsol is now from Victoria's description. So Iberdrola is suing Repsol on the basis that it's carried out a greenwashing strategy. Now, what advertisements does it have in mind? So the wording is on the screen there, some of the claims that Repsol has made. And in particular, Iberdrola is taking issue with the claim that the quality of Repsol, now 100% renewable from organic waste, available in more than 50 gas stations and in more than 600 by the end of the year, new fuels 100% renewable. So we can see the basis of the claim there from Iberdrola's perspective. In terms of how they've founded the legal basis of the claim, their claim is in unfair competition law. They've based it on specific Spanish articles, so the acts of deception, which are Article 5, misleading omissions, Article 7, and illegal advertising, Article 18. But there are similar legal provisions in different jurisdictions, including the UK. Looking specifically at what Iberdrola is claiming, they say it's relevant to competition law because, in their argument, it's likely to alter consumer behaviour on purchasing Repsol products, and it constitutes, therefore, a relevant variable in the consumer's perception of the company as green or sustainable. In terms of how these cases are brought, I think the Repsol challenge is interesting. They're not claiming damages. What they are claiming is that they want Repsol's campaigns to cease. And so, in essence, what they're trying to do is stop that commercial advantage, which they say Repsol shouldn't have. Now, the hearing took place in November 2024, so just before Christmas, and the decision is awaited. So it'll be interesting to see what the outcome of that decision is. But why is the case interesting when we look at it at this stage? Well, the first is that it's a clear example of that competitor versus competitor action being taken. Indeed, it's the first trial of that nature between companies on greenwashing in Spain. The second point that I think is interesting is that there are, of course, differences in Spanish law, but because much of it is EU derived, there are similars, of course, with the legislative background in the UK, with its EU background. And finally, and it's really the key point for me, is that when we look at this case, we see the clear hallmark of a regulatory decision being taken, attention being drawn to a certain issue, and then finally that being the catalyst for a claim being brought in a private law context. So I think that's a really interesting point about the case. Two other examples. The Iberdrola and Repsol case, it isn't, a once-off. If we look at other jurisdictions, so Italy, we have the case of Alcantara and Mico. Now, this was an Italian decision decided in 2022. In terms of the background there, you can tell from the slide, it concerns the exciting topic of microfiber products for motor vehicles. Now, the case was initiated in July 2021. In terms of the two actors, we have Alcantara, and they filed a request for an interim injunction against one of its main Italian competitors who markets a suede-like microfiber product called Mico. Now, what was their issue with Mico's advertisement? So, several issues in terms of the language they used. Fundamentally, they disagreed with Mico characterising its product as it did in terms of green claims and promoting it as environmentally friendly. Some of the language they used is on your screen there. So made of recycled polyester, environmentally friendly, natural choice, eco-friendly, microfiber, 100% recyclable. So I think it's fair to say, looking at that language, not language that anyone here would be unfamiliar with in terms of other companies making similar claims. In terms of the likely success that Repsol or the Iberdrola case might have, I think it's interesting to look at what happened with this one. A similar basis, it was also taken in unfair competition law, in that case under the relevant provision of the Italian Civil Code, but very similar. They said it was misleading advertising as defined in the Unfair Commercial Practice Directive, and they alleged that the claims were vague, false, non-verified or non-verifiable, all of which the court ultimately agreed with. In terms of the sanction, they ruled in favour of the claimant. They said that the ads had to be immediately removed from the various different sources where they were online and also in print media. And it said the court had ordered Mico to publish the court's decision on its website for 60 days. So again, like the Repsol case, I think it shows companies being very keen to protect their market share by not allowing false claims to be made. But I think it also shows the declaratory effect of some of these decisions. Certainly, having to have this decision on your website for 60 days would not be welcomed by Mico, or indeed, I would say, many competitors. As a final footnote to that case, I would note that for procedural reasons, it was reversed on appeal, but not the substantive reasoning. So I think it still gives us a really helpful indication of how a court might deal with these kind of issues. Again, why is the claim interesting? Well, that was the first time that an Italian court ordered a business to stop making green claims at the request of one of its competitors. Very similar to the Spanish litigation. It's originally, initially, these kinds of cases were typically taken by the Italian competition authorities or Italy's advertising standards authority. So I think a very similar story in terms of the cases where it starts with regulatory action and then it develops into something like a competition claim. And then finally of note, of course, is that even though this was based on Italian law, the underlying law was the Unfair Commercial Practice Directive. So again, clear implications for other companies within European jurisdictions, and of course, any companies with similar legal provisions like the UK. And the final example in terms of competitors, now this is a kind of simple one. You'll see a candle on your screen there. This was a July 2013 decision of the Düsseldorf Regional Court. And I like this decision because it's a short decision, but it shows the simplicity with which sometimes these issues can be viewed. So in terms of the background, December 2012, a candle manufacturer was sued by a competitor because of an ad in a newspaper that contained the wording you can see on your screens there. So it said, climate neutral candles, all candles produced are climate neutral, and that it said the defendants strive for zero carbon emissions and consistently ensures climate neutrality. So the plaintiff in that case argued that its competitor's claim was misleading and that, again, it violated competition law. And the Düsseldorf court agreed with the claimant in that case in July 2013. As I said, it's a simple decision, but they said from a consumer's point of view, it wasn't out of the question that there existed new materials or combustion techniques without CO2 emissions. And it was precisely for that reason that this constitutes an unfair practice on the part of the defendant. And they said its claim that its candles were climate neutral was misleading. I think it's a clear area, again, because it shows the simplicity with which some of these issues can be viewed. And it marries over that logic we see in the regulatory context. So how would a consumer view the claim that you're making? And they tend not to view it with caveats and footnotes. They take it at face value. So again, a clear reflection of the way in which competitors will also have an interest in taking these kinds of cases increasingly. The next area, and certainly a large area of claimants, will be consumers. So many of those tuning in will be familiar with certainly the background to the Volkswagen high-profile greenwashing penalties they received when it was discovered that there was a defeat device in certain cars. So in terms of the background to that regulatory action and those fines, in 2015, the US Environmental Protection Agency accused Volkswagen of violating the Clean Air Act after discovering that the company had used software in its cars that recorded lower greenhouse gas emissions. In reality, when they looked at how much nitrogen oxide pollution was produced from the car, it was about 40 times that of US law at the time. So a very clear breach of environmental law. And in 2020, in terms of the impact for Volkswagen, they stated that Dieselgate had cost the company over $34 billion. So come back to that later in terms of the impact on companies. But there's a quote on your screen there that I think really clearly summarizes the position. And it's the Volkswagen America CEO, Michael Horn, in 2020. And he said, our company was dishonest with the EPA and the California Air Resources Board and all of you. So a pretty clear statement from the company there. So why is that interesting for our purposes? Again, it shows conduct which is in that regulatory space where fines are imposed. It's clearly a very serious example of greenwashing type conduct. And, as we've been discussing with Victoria and Catherine, this is a very clear breach. A lot of breaches will be inadvertent. But nonetheless, what I think is interesting about this example is if you look at how this has been picked up in the civil context, and that's where we get to the Pan-Nox litigation or Dieselgate, as it's also being reported on. So there are currently proceedings in the High Court in England where customers allege that there existed similar prohibited defeat devices in vehicles manufactured by no less than 13 manufacturers. So a very significant piece of litigation. Similarly, they say those devices were fitted to manipulate the nitrogen oxide results that would be reported during testing. Now, in terms of the numbers, in terms of who's involved in that case, over 1.5 million claimants. What that means, of course, is that there's been a series of group litigation orders made by the president of the King's Bench Division. But what's really interesting is if you look at the basis of the legal claim that they're bringing. So, of course, there's the background to these being defeat devices, but broadly speaking, they fit into 5 causes of action. So the first is a breach of statutory duty. Second, deceit. Third, negligent misstatement. The fourth is a breach of contract, and finally claims under the Consumer Protection from Unfair Trading Regulations 2008, which Victoria, of course, referred to in her presentation. So it shows the extent to which something might start as the motivation of a kind of greenwashing claim, but it can very much be fitted into different established causes of action in the civil context. Again, it's a clear example of that migration from a regulatory space, ultimately drawing attention to an issue and then it resulting in a private law claim. And it will certainly be one to watch because the first substantive trial will be taking place later in 2025. Now, I referred there to the losses that Volkswagen suffered as a result of their Dieselgate scandal. What that also shows is the fact that there are various different actors who can be interested in bringing litigation. So, of course, it can be that first category of competitors. It can be consumers who buy the products, of course, and feel that they wouldn't have bought the product if those claims hadn't been proven to be false. And then finally, it's shareholders. And I think that's really relevant. So to flag that briefly, many of us will be aware with the two citations that are on the screen there of a case that was taken by Client Earth against Shell in 2023. They were twice refused permission in May and July 2023 to bring their shareholder action claim. The judgment itself is interesting, I think, in setting the parameters of, why that case was unsuccessful. Of course, in terms of the basis to their claim, it was different to what we're talking about today. Client Earth's claim in that decision was brought on the basis that Shell's strategy to manage its climate change risk was insufficient to reduce the company's greenhouse gas emissions. So a different context. But I think what's interesting about highlighting those two examples is first, it shows this is an increased area of focus, shareholders thinking about how their property rights are implicated or how the value of the shares are affected by claims which are not made out by the company. And then the second point is that when one looks at the Shell case and thinks, why was that claim unsuccessful? One of the main points of reasoning that rightly, I think, comes out from the judgment is that they emphasize that directors of a company are trying to make management decisions. And so the court will be slow to interfere with these, particularly when they involve competing interests. But I flagged a different provision on your screen there, which is interesting in this context, and I think is very relevant to climate change and also greenwashing. So if we look at the wording there of Section 90 and Section 90A of the Financial Services and Markets Act 2000, FSMA, that provides redress for shareholders in a listed company where false or misleading claims are made. Now, there's many claims that have been brought in relation to different claims under FSMA, of course, not in this space. But when one looks at the wording, one can see how relevant it might be. So Section 90 provides any person responsible for listing particulars is liable to pay compensation to a person who has A, acquired securities to which the particulars apply, and B, suffered loss in respect of them as a result of any untrue or misleading statement in the particulars. So one can see the increasing focus that might be on a company to make claims that they are trying to align themselves. And then finally, of course, one can see the loss that might be suffered. So briefly referring to that case there, the US case of Swanson and Danimer, that's a case filed in the US where a plastic substitute was found not to be as renewable as the company had claimed. There was an article in the Wall Street Journal and huge losses were suffered, and that claim is ongoing. So again, an interesting case to highlight and something to leave us with on a thought. So I'm going to bring back Victoria and we're going to do a brief closing points here if Victoria has some key takeaways and what's on the horizon.
Thanks, Ruth. Yes, just in the couple of minutes we've got left, a couple of takeaways from me. I think for my part, the legislative and regulatory regimes, they have evolved in the UK, and there has certainly been this paradigm shift for businesses operating in the UK as well as sort of globally. So we've got greater regulation, we've got greater scrutiny and actions by regulators and others like NGOs and competitors, as Ruth has sort of talked about, and the risks there. There's these enhanced enforcement powers coming into force. And there's this greater collaboration between regulators in the UK and the greater use of AI to identify greenwashing. And that really does up the ante in terms of risk for businesses when making green claims. But I think one takeaway for audience and others that listen to this is there is new guidance. There's lessons to learn from rulings and investigations, and businesses, if not already, should be looking to adjust their practices to align, drawing on what's available out there. Prioritize compliance, and in doing that, they'll safeguard themselves from potential legal repercussions that we've talked through today. And certainly looking ahead, I think one area to really watch is what happens at the CMA and its use and impact of its new enforcement powers under the Digital Markets Act, which will be available from April this year. And we expect the CMA want to start to use those powers in earnest. Any final thoughts from you, Ruth?
Thanks, Victoria. So I think what's been really interesting thinking about that regulatory area into public law and into private law is how interconnected all of these areas are. And certainly as there are new powers, as you discuss, the new focus is going to be on this area for good and for bad. I think companies will try to improve what they can for the environment, but of course the fundamental thing is that those arguments have to be true and have to be evidenced. So I think with that, we're just 1 minute over time, which is reasonably good timekeeping. Thank you to Victoria for joining myself and Catherine at 39 Essex Chambers. And thank you to everyone who's tuned in to listen to today's webinar. Thank you.
Thank you.